Thank you very much, Madam Chair, for the opportunity to address you and to the members of the committee. For the record, I'm Justin Jones, representing State Senate District 9 in Clark County, here to introduce Senate Bill 203 for your consideration. I've introduced Senate Bill 203 for one simple reason. I think it provides another tool to foster good government, and good government requires transparency in lobbying and legislative activity. Senate Bill 203 is a simple bill which amends NRS 218H to require that a registered lobbyist must file a quarterly report of lobbying activities during the months that the legislature is not in session. Currently, NRS 218H requires only that registered lobbyists file reports covering their activities during the legislative session. Specifically, they must file monthly reports during regular and special sessions and one final report 30 days after the close of the session. However, we all know that a great deal of lobbying goes on during the interim. Many registered lobbyists have an interest in the work of the Legislative Commission, the Interim Finance Committee, and the interim committees. They testify formally before these committees, but they also request private meetings with legislators to represent the interests of their clients. They work on issues that will be considered in the next legislative session. There is nothing wrong with this. Lobbying is an essential part of the legislative process. We all rely on lobbyists as an important source of information. The purpose of this bill is that our constituents have a right to know, the public has a right to know, which lobbyists are actively engaging in activities during the rest of the time outside of the legislative session. I think it's equally important to address what SB 203 does not do. It does not affect the definition of lobbyist. If a person is exempt from filing lobbyist reports now, that person will be exempt from filing lobbyist reports in the interim. If a person is required to register now, he or she will be required to register and report during the interim if that person is engaging in lobbying. That's my second point. If a person who lobbies during the session is not going to lobby during the interim, that person can file a termination report giving notice that he or she will cease lobbying activities. People who do this only have to file the activity report for the last period in which they are lobbying, and then they have completed their obligations until they register once again to lobby, probably at the next legislative session. Now, some of you may remember in the last legislative session that a similar bill was introduced. Some questions were raised about unpaid lobbyists and whether they would be required to file these reports. Testimony indicated that some unpaid lobbyists would be discouraged from participating in the interim process, especially if one of them forgot to file a quarterly report and was penalized. To address this concern, SB 203 provides on page 3, lines 37 to 40, that a registrant is not required to file a report pursuant to this subparagraph if the registrant did not receive compensation for such lobbying activity. It is my hope that this provision lays to rest those fears, but I would like to go on record as stating that I am willing to consider other provisions to exempt unpaid lobbyists if they are still uneasy about this bill's impact on their participation in the legislative process. We need our citizen lobbyists. In summary, Madam Chair, SB 203 advances good government by requiring paid lobbyists to report activities through the interim as well as the legislative session. I would ask for your consideration upon this bill.